Aging Insight, empowering you through the aging process.
Being involved in the special needs community is something we've been a part of a long time. Some of y'all may know, some of you may not, but Lisa has a twin sister that was born with a brain injury. And her name's Leanne. And Leanne lives at Holy Angels in Shreveport, which is a real nice facility over there. And Leanne's wonderful. She likes to go out to eat. We're actually Leanne's coming up in a week or two, going to stay the weekend with us. She's been calling almost every day, 4 or 5 times a day, to make sure the plan's still on. We're going to Roadhouse. She's already decided she wants to go to Roadhouse, and she's already asked me 4 or 5 times if they have chicken strips at Roadhouse. So she's pretty excited about coming. When I got out of the Marine Corps, I worked at a place called Always Wanted a Riding Experience, which was a therapeutic horseback facility, kind of like the Running WJ Ranch here in town. They had a single wide trailer out on the horse ranch, and I could live there for free as long as I shoveled horse manure twice a day. Which was a pretty good deal when you manage to do 4 years in the Marines and get out with $50 and the GI Bill. So anyway, so today we're going to be talking specifically about special needs trusts or supplemental needs trusts. You will hear me use these words back and forth, special needs trust, supplemental needs trust. I'm talking about the same thing. 2 words for the same sort of thing, all right? So don't get confused if I say supplemental needs or special needs. I'm talking about the same thing. But let me give you a background. So I go off to law school with the idea of doing trust planning. My background was in tax. I knew that when it comes to doing tax planning, particularly when it comes to like the death tax, which at the time was a big deal. It's not a big deal anymore. You know, for a married couple, you'd have to have $22.8 million or more to have to worry about the death tax. Most of us gonna slide right under that. So, but I knew back then, all you had to have was $625,000. Anything more than that and everything above that was going to get taxed at 50%. And there was all kinds of trust planning that you could do to help with that. So I go to law school, I study trusts, I get out of law school, and I'm the trust guy. I'm doing trust for people. And so I get a call. I'm a baby lawyer. I mean, I've only been practicing law for 6 months, a year, or something like that, very early on. And I get a call from a couple of plaintiffs' lawyers here in town. And they say, John, we've got a young man that tried to beat a train on his bicycle. And he missed. The train ran clean over him, took off both arms at the shoulder and one leg at the thigh. That's pretty bad. The day of the accident, it's a back road in the middle of nowhere, and here's the road that goes over the railroad tracks, and right up next to the road on both sides are 50-foot tall pine trees. 24 hours after the accident, there's not a pine tree in sight for 100 yards on either side of that road. Well, I don't know anything about that kind of law, but, oh, you know what? That's why it's doing it, because this thing's hanging down here. Now I look like Britney Spears. All right. I don't have to talk as loud either. All right, let's try that again. Anyway, so these plaintiffs' lawyers, they call me and they say, John, we've been in a lawsuit with this railroad company for about 2 years, trying to get this young man some money. And we have finally reached a settlement, $1 million. And that sounds like a lot of money. Now, we're talking about a gentleman who can't feed himself, can't brush his own teeth, can't do anything. And during this 2-year period, he has qualified for various government benefits like SSI, Medicaid. In fact, if you qualify for SSI, which is the most need-based government benefit, that's the hardest one there is to qualify for. And if you qualify for Medicaid, if you qualify for SSI, then you're going to qualify for just about any other government program there is. So you get your SSI, you get your, I'm trying to make it where it's not echoing there. Anyway, if you get your SSI, then you're going to get your Medicaid, that's going to be your health insurance, but then there's also all kinds of other Medicaid programs, in-home care assistance and all of these other things. And so this young man got all of these programs, all of which are paying for people to come to his house, help him prepare meals, help him get dressed, go to the bathroom, do all of the things that he can't do as a triple amputee. If he gets $1 million, all that goes away. And again, $1 million might sound like a lot, but if he was private paying for all of the services he was receiving, he would burn through that $1 million in about 3 years and be back to having nothing. And all those government programs are great. They provide very necessary resources. They do not provide cable television. They don't take you out to eat. They don't buy you video games if that's what you like. Or if you're like Leanne, she likes coloring books, and they don't buy her coloring books. They don't buy her new clothes. They don't put furniture in her group home. There's lots of things that they don't do. Kind of like when I was in the Marines, they used to say, John, I don't know what you're complaining about. You got 3 hots and a cot. You got food in your belly and a roof over your head and a place to sleep at night. What else do you need? Well, I need a lot, actually. In fact, I'm kind of a princess when it comes to that sort of thing. That's why I got out of the Marines. So these plaintiffs' lawyers, they call me and they say, hey, John, you're the trust guy. Can you set up a trust where this money can go into that trust and this young man still keep all the benefits that he's on? And I said, oh yeah, I got it. No problem. No idea how. No idea whatsoever. It seemed like there had to be a way. And sure enough, there was. And so what we're talking about here is a supplemental needs trust or a special needs trust. Now, all a trust is a stack of paper. That's it. And all trust, no matter what kind of trust you're talking about, it's going to have 3 things in common. It's going to have somebody that creates it, somebody who's in charge of it, and somebody that receives the benefit of it. And depending on the context, these could be all the same people, they could be all different people. You know, I could create a trust, so I create it. I could appoint Lisa Scholmeyer to be in charge of it, so she'd be the trustee, and we could set that up for the benefit of her sister Leanne. You know, so all 3. So there's lots of different ways you can set it up. But what makes a trust a supplemental needs trust is the words in there. And those words are going to say something like, the money from this trust can be used for the benefit of this disabled person in just about any way, shape, or form, so long as the distribution doesn't affect any government benefit. If the distribution would affect a government benefit, then the trustee is prohibited from making that distribution, right? And so what happens here is you get SSI or Medicaid or somebody, and they look at this trust, and they're looking at the trust to try to see, does this money disqualify the beneficiary? Could the beneficiary get any of this money in a way that would disqualify them? And right there in the middle of the trust, it says, no distributions can be made if that distribution would disqualify the beneficiary. It can pay for anything else, but nothing that would disqualify the beneficiary. And what that does is that means now the assets of that trust are not going to count towards that beneficiary's eligibility for any of those government benefits. But, Medicaid doesn't pay for cable television. But if the trust pays for cable television, that's fine. This thing's annoying. The trust, the Medicaid doesn't buy you new clothes. We'll just cancel that one. All right, camera guy, you're probably going to have to turn the sound down now. We're going to get back to Marine voice. I can talk to a room, that's not a problem. All right, so get rid of the microphone there. So the whole idea, and the reason you'll hear it referred to as something like a supplemental needs trust is because it's there to supplement but not replace the government benefit. All right? Now, it's a little more technical than that. You can probably get some idea, but that's the general idea. And you can start by breaking these two. Now that we know what a supplemental needs trust is, we got two different types. And the two different types depend on where the money is coming from. And the example that I used, where we've got this guy that he's getting this money from this personal injury, that's his money. And so he wants to take his money and put it in a trust that he's the beneficiary of. All right? So the disabled person is using their own money so that they can qualify for benefits. All right? That's what's called a first-party special needs trust. First party being because the person that creates the trust is the same person that is funding it with their own assets. They're creating it, they're funding it, they're not in charge of it, but they're creating it, they're funding it. The other type would be where you're creating a special needs trust for somebody else. The example I used a second ago of I create a trust with my assets for the benefit of Leanne. So now I'm creating it for somebody else, and that somebody else is the disabled one. That's a third-party special needs trust. These two are identical in every way except for one. You can imagine that the government is probably not all that keen on somebody being able to take their own $1 million, throw it in a trust, and then turn around and qualify for SSI and Medicaid and all these other things. And so the rules say that they will let you do this on one condition. And the one condition is that whatever is left in the trust at the time of your death has to go back to the state to reimburse them for whatever they have been paying for. So this is what's called a payback clause. So if I'm creating the trust for my own benefit with my own money, that's fine. I can still qualify for Medicaid and all of that, but whatever I don't use is probably going to go back to the state when I die. All right? Now, you take like this young man who was in his 30s and has a full life ahead of him. He may very well use all of it over the course of his lifetime, in which case there's nothing to pay back to the state. No big deal. On the other hand, if he got the bright idea to try beating that train a second time and didn't make it this time, then whatever was left would be going back to the state, at least to however much they had paid for it. And when it comes to things like Medicaid and all of this, the state can rack up a big bill pretty fast. So with a first-party trust, it's got to have that payback. But if I'm planning for somebody else, if I'm taking my assets and I'm going to put them in trust for somebody else, I can make this say whatever I want, and I don't have to include that payback provision. So I can say, I'm going to create this trust, I'm going to take my money, put it in this trust for the benefit of Leanne, and at Leanne's death, I want it to go to my cousin Stewie. And that's fine. It doesn't have to go back to the state. So third-party trust, no payback provision. First-party trust, got to have that payback provision, or else it will disqualify the person from the Medicaid. So those are your two. You got first-party trust, you got your third-party trust. Either one of these, and primarily with the first-party trust, but either one of these, you can generally distribute out of that trust for just about anything. Sort of. Comma. If you're talking about somebody who's on SSI, I mentioned earlier that SSI is very, very strict. If you receive SSI, Supplemental Security Income, not to be confused with Social Security Disability Income, SSDI. If I've worked and paid into the system, get hurt at work and can't work anymore, then I'm just getting my Social Security early because I'm disabled. That's Social Security Disability. That has nothing to do with my assets or anything. That's because I paid into the system. If I never paid into the system, or I didn't pay enough into the system and I'm disabled, then I get SSI. The maximum benefit's about $750 and some change, all right? But any other money I receive, for every dollar that I get in some other form, like if I'm on SSI and you gave me $1, my SSI is supposed to go down $1 for that month. If you gave me $5, it's supposed to go down $5. If you gave me $800, that would reduce my SSI benefit below zero. If it reduces it below zero, I lose the SSI. If I lose the SSI, I lose the Medicaid. That's my health insurance. I lose the Medicaid, then I'm going to lose my sitters or my attendants, or if I'm at a nursing home, I'm going to go to private pay, or whatever the deal is. And so something as little as $800 could cause that to happen.
That's on SSI.
This is on SSI. Now, so if I'm on SSI, I got to be very careful. And the way Medicaid and the SSI look at it is if you distribute cash out of a special needs trust to the beneficiary, that's treated as income. So if you took $1 out of that trust and gave it to the beneficiary, that's going to reduce their benefit by $1. And so on. And so if you took cash, if you give them cash, you could potentially disqualify the person. All right? So although you can use it for just about anything, you'd want to be very careful and probably not give cash, because that could have an effect. The other thing, and I'm not entirely sure why this is in the rules, but it says that you're not supposed to pay for food or shelter expenses, and that any payments for food or shelter will reduce the benefit. Not necessarily to zero, but they will reduce the benefit. A lot of times, if, like, let's say I had a child with Down syndrome that lived with me at the home, they're eligible for SSI, they would get their full $750 benefit, but if I let them live there for free with me, SSI says they're getting free housing, so they're going to cut their benefit to about $500. They're going to cut it by 30% because they're getting free housing. So you know what I'm going to do? I'm going to charge them rent. I'm going to charge my own disabled child rent to live in my house, but I'm going to do that so that they're not getting free housing. And that way they'll get their full $750. But this same rule would apply if I had a trust over here and this trust was paying for the person's rent. Well, that's providing housing, which is going to cut their SSI benefit by 30%. All right? Same thing applies to food. So generally speaking, you can pay for just about anything. I can pay for cable, I can pay for all of these other things. I can buy them a car, I could buy them all kinds of stuff. But if I give them cash, we got a problem. If I pay for food, we got a problem. If I pay for housing, we got a problem. All right? This has been a problem for a long time. And government moves slow on trying to solve problems, especially when it comes to a community like the disabled community. But in 2014, they finally came around with a very unique and very brand new solution. Any of y'all ever heard of a 529 account? The 529 accounts are like our college savings accounts. So if I wanted to put some money back for one of my kids so that when they get to college there would be money, there's an IRS section, IRS section 529, that creates a special account that I could put money in for my kids' college. And that money would grow tax-free. And if they pull it out and use it for qualified education expenses, they can pull it out tax-free. Pretty cool little deals. In 2014, they added section 529, capital A. And the bill the name of this bill was called Achieving a Better Life Experience Act, ABLE. This created something called ABLE accounts. An ABLE account, a beneficiary or their family member can set up an ABLE account. Works just like a bank account. The beneficiary could put their own money in it. Other people could add money to it. There's a limit of $15,000 per year that you can put into an ABLE account. But when they wrote this law, they said that money that's in that ABLE account can be used for that beneficiary in any way, shape, or form without having any effect on SSI or Medicaid or anything else. So let me give you the example. Let's say I set up some money in a special needs trust for Leanne. Now, Leanne loves one thing more than, well, she loves two things more than just about anything in the whole world. Dollars and Reese's. Dollars and Reese's. If it's Valentine's Day and she has not gotten a card from me that contains both dollars and Reese's, I'm going to hear about it. And not just then, I'm going to hear about it next year and the year after that. I still hear about the first year because the first year I sent her a $5 bill. That was a mistake because according to Leanne, that year I only sent her $1. Everybody else sent her $3. But I just sent her $1. All right? But Leanne really does like some Reese's. And because she has some dollars, she likes to go to the store and buy her some Reese's when she gets a chance. And at the group home, they take them shopping and let them do some. And the more higher functioning folks, they actually go out and Lisa teaches the special needs Sunday school class over at Trinity Church every Sunday. And one of the students in her Sunday school class, we ran into him at the Texarkana Wine Festival. He's out buying some wine at the wine festival. Right? So, special needs, there's a whole range in here, right? And so, anyway, so let's say I've set up this special needs trust for Leanne, and I want to give her some cash that she can spend. Well, I can't give her the cash right out of the trust because that's going to cut her SSI benefit. But now, with this new ABLE account, I can just put that cash in the ABLE account. And that ABLE account can be spent in any way, shape, or form, which means I can put it in the ABLE account and then pull it out in cash. And now she can have it. Or I could just give her the debit card and she could spend out of that ABLE account. That ABLE account could pay for housing. The ABLE account could pay for food. It can pay for anything. And so now the combination of a special needs trust and an ABLE account really does mean that you can do anything for that beneficiary without messing up their benefits. You just have to make sure which one it's coming out of. So the ABLE accounts were fantastic. These are even particularly if you have a disabled person that maybe wants to work. And a lot of times they want to work, they're going to earn some income, but they don't have anything to spend it on. And they accumulate. Well, if you're on SSI, you can't have more than $2,000. If you got more than $2,000, you lose the SSI. You lose the SSI, you lose the Medicaid and everything else. And so now that disabled person can go out and work, and if they start to accumulate money, they can just put that in the ABLE account before they get to the $2,000. Pretty cool. So now they can work. In fact, if you have a disabled working person, they're not even limited to the $15,000. They can go up to about $25,000 a year into that ABLE account without it having any effect. And the ABLE account can go all the way up to a balance of $100,000 before it affects their eligibility. So those are pretty cool little deals. So the combination of special needs trust and ABLE accounts are very powerful. Now, any questions about any of that so far?
Yeah.
You got a question?
You know, the government changes things down the line a lot of times.
Yes.
So say they do this ABLE account, which is really great, and then 5 years later the government says, okay, we're not going to do that anymore.
Yeah, so your question is, well, you know, we got this brand new law, 2014, created this ABLE account, and even when they created the ABLE account in 2014, Texas didn't get around to doing their part so that Texas residents could use ABLE accounts until, I think, last year, maybe 2017. But anyway, your question was, well, what if I've got this disabled person, I put some money in an ABLE account for them, and then in 5 years they change the laws? Who knows? I mean, obviously, to some extent. But here's what I will say. If, for example, you look at the Medicaid rules, there's a whole section in the Medicaid rules about trusts, all right? And if you look at all of those rules, you'll see where it says trusts created 1985 and earlier. And then the next section is trusts. Here's the rules for trusts created between 1995 and 1992, and 92 to 2005, and then 2005 to present. And what they have done is every time they have changed the rules, they've grandfathered in anything that was already in existence that would have been disqualified under the new rule.
Can you still add to it?
And yeah, so you could still use it if you already had it and things like that. So I can't say what the future holds, but historically, you can kind of look back and say, if you did something under a law and was valid then and they changed the law where it's not valid anymore, you're probably still good. But you're right that they do change all of this stuff pretty regularly. It's like throwing darts at a moving dartboard a lot of times. But now I've talked about all of this special needs planning, and I bet as I've talked about all of this special needs planning, especially since I've used examples like Leanne and using the example of having a child with Down syndrome, you've been thinking about people who have a child with Down syndrome, or somebody like Leanne and their family. You have not necessarily been thinking about yourself or your loved one. If you have a husband and wife, and let's just say that the wife has been diagnosed with Alzheimer's, and the reason she's able to stay at home is because the husband is there providing her care. Very common. The life expectancy of somebody with Alzheimer's is 15 years from the time they're diagnosed. It's a terminal condition, 100%, so they're going to die from it, but it's going to take 10 to 15 years for that to happen. The life expectancy of the husband caregiver is 3 years. He's going to die from the stress of being a caregiver. And when he dies from being the stress of a caregiver, he's going to leave behind a spouse who cannot handle any of her own affairs, is not going to be able to live on her own and is probably going to now need something like somebody to stay with her in the home or assisted living or nursing home care, all of which is very, very expensive if you're private paying for it. On the other hand, if you could qualify for benefits like Medicaid, well, then you've got the state paying for that. And I bet if I were to grab that husband and wife right off the street and say, hey, have y'all done any estate planning? Well, 60% of the time the answer would be no, because that's how many people in the United States die with no estate planning, 60%. But if they were one of the 40% that had done some estate planning, here's what they would say. Yes, we have wills. And the will says, I leave everything to my wife. The wife's will says, I leave everything to the husband. And in both cases, it says, if the spouse is not around, we leave everything to the kids in equal shares. If they have anything at all, that's what it says. Guaranteed. All right? But now put it in this context. Husband dies, leaves behind wife. Wife can't handle anything, needs Medicaid, going to a nursing home, and husband's will just left her everything. And as a single person, the rules for qualifying for Medicaid just about like SSI. She's going to be limited to about $2,000 in total assets, not counting her home and car. But what if the husband's will said, I leave everything to my wife, but if my wife needs Medicaid or something like that after my death, then everything I leave behind, I want held in a special needs trust for her benefit. Now he dies, everything goes into a special needs trust for the wife, and that money doesn't have to be spent at $6,000 a month for the nursing home. Bam, that's a big deal. Now that money can be used to help with, all the other things that the nursing home and Medicaid are not paying for. I mean, they probably still have a house. Who's going to pay for the upkeep and maintenance on that house and the ongoing utilities and things like that? In fact, they may even want to sell the house. But if you sell the house, you got cash. And the cash is going to disqualify her from Medicaid. But if everything is now held in this special needs trust, then we've shielded all of those assets. And this is created by husband for wife. It's a third-party trust, which means when wife dies, whatever's left in that trust, going to go to the kids, just like it would have anyway. And maybe they've got 2 kids, and maybe those 2 kids are perfectly healthy and happy and doing great today. What's their future look like? My oldest client so far was 111. I've had a bunch over 100. I had one guy, I was at his 106th birthday, or I guess a couple of days after his 106th birthday, and he was telling me about his honeymoon where they had gone to what eventually would become Yellowstone National Park. And they were visiting with the sheriff out there at Yellowstone in the county area, and they told the sheriff that they were there on their honeymoon, and he said, well, then I got a little surprise for you. And he took them around to the back of the police station, went down into the basement, and pulled out a bottle of wine. This was the middle of Prohibition. The guy's 106, right? Sheriff's seizing it when it's coming in from Canada, supposed to be destroying it, and he's just stockpiling it up under the police station, giving it out as gifts to random tourists. Now, I mention my 106-year-old because you know what happens if you turn 106? All your kids are old. And the kind of things that you were worried about when it related to your own health, if you're in those retirement years and you're in the 70s and you're thinking, geez, what happens in 10 more years when I'm 85 and I have Alzheimer's? Well, guess what? That 111-year-old client of mine, their child was 91. So the thing is people have a tendency to focus on themselves. They're worried about their wife, or they're worried about their husband, or they're worried about themselves when they get old. But as you get older, your kids will get older, and their lives can change as well. And so if I have 2 kids who are perfectly healthy and happy today, but 20 years from now I die, leave everything to those 2 kids, and one of them has become disabled, they're probably on need-based government benefits. I probably just disqualified them from those same need-based government benefits. So really, maybe I ought to say, I leave everything to my wife. But if my wife needs something like Medicaid, then I want it held in a special needs trust for her benefit. If we both die, we leave everything to the kids in equal shares. But if one of them has become disabled, we want their share held in a special needs trust. If you can protect a beneficiary that might become disabled by just providing a contingency in there, why wouldn't you? There's a pretty good argument right now going among the legal community as to whether or not the failure to include that kind of planning is malpractice on the attorney. If I have the ability to protect your disabled beneficiary and fail to, whose fault is that? It's mine. So you can make a pretty good argument that really contingent special needs planning is appropriate for anybody unless you're leaving everything to a charity. Charities don't become disabled. But if you're not leaving everything to a charity and you're leaving it to something that has a pulse, that pulse may be disabled, it may be on government benefits, and if you haven't planned accordingly for that, you're going to probably do as much harm as you are good. And so yes, if you have a disabled person, no question about it, special needs planning. Special needs trusts are the most powerful tool to provide resources for a disabled person. And if you have a disabled person, you should have a special needs trust established for them. Period. End of story. No question about it. You should also coordinate that probably with an ABLE account, again, depending on circumstances. But the special needs trust, really no question about it. But for everybody else, you should at least be building in that special needs planning as a contingency. I leave everything to my wife. It's fine. She can bring her next husband to the funeral. But if she's in a nursing home, I want it held in a special needs trust for her benefit. I leave everything to my 4 rotten, no good, ungrateful teenagers. But if one of them is disabled, I want it held in a special needs trust for their benefit. Easy. You're taking a tool, it's been around. And the ability for a spouse to create a special needs trust for their surviving spouse was put into the law in 1995 by Bill Clinton. So for 24 years, a spouse has been able to protect their surviving spouse. How many of y'all was that the first time you heard of it 5 minutes ago? And yet, for 25 years, that's been on the books. It's just that, and when I mentioned I went to law school, I studied trusts. Nothing about any of this. Nothing. 3 years of law school with a focus on trust, nothing. So, all that to say, special needs trusts, very powerful, they're very cool, they do a lot of things, and they can be used in a lot of different contexts. Any final questions about any of this stuff?
Say you have 4 children, and one of them is disabled, and you do this trust. Okay, you die, the money goes to, how would that money be distributed? You can't put it all for the disabled one. Won't the other 3 children get kind of screwed?
So your question is, what if I got 4 kids, one of them's disabled, how do you divide it among the four? And if you provide more to the disabled one, are the other three going to get mad about it? Well, if they are, then they're sorry, SOBs. And I say that somewhat seriously. But you want to be fair. And so part of that would depend on the nature of the estate, right? $100,000 in the context of an adult disabled person is not a lot of money. And so if your net worth is $100,000, providing all of that or 75% of that to the disabled person is perfectly reasonable, because that's in the context of a disabled person and their life expectancy, that's just not a lot of money. On the other hand, if you're Jeff Bezos and you got $50 billion, right? Even if we split that 4 ways, a quarter of $50 billion still going to be plenty for the disabled person. So some of it's going to depend on the nature of the estate, things like that. Some of it are going to be age and stage. If one of my 4 kids had a disability other than teenager, and right now that's a relatively debilitating, but one that they're expected to recover from. Maybe not. Yeah, but I'm hopeful. I'm hopeful. But let's just say that one of them was disabled. You know what? I might leave my planning where it splits everything 4 ways, but I might go buy me a life insurance policy that's payable just to the special needs trust. And so everybody gets an equal share, but the trust gonna get more because it's the beneficiary of that life insurance policy. So there's different ways that you could do it. You do want to, if and depending on family dynamics and things, anytime you're doing a disproportionate distribution, you do want to anticipate the possibility that somebody's unhappy about it. And so being very careful about how everything is planned and making sure that it's as Loctite as possible, not a bad idea. But when Lisa Schulmeier's dad had terminal liver cancer, and he's got Lisa and Leanne disabled, and then they have an older sister, Danye, as well, and he was very concerned about leaving everything to the 3. And he kept telling Danye and Lisa, well, I want y'all to have stuff. And they kept telling him over and over, we don't want nothing. Leave it all to Leanne. Put it all in the special need. Leave it all. But he was the one that really had the problem with it. And so ultimately he ended up splitting everything 3 ways, and then Lisa and Danye just put theirs in the special needs trust. So you can kind of do it. It depends on family dynamics. Yes, ma'am. Yeah, so your question is who, and just generally speaking, who's going to be in charge of a special needs trust? You get to pick, and you can pick multiple alternates. So like, with Leanne, you've got Lisa and Danye, the 2 sisters. Something happens to one of them, it's the other sister. Something happens to both of them, it's me. And so you can have a list of alternates. You can also have corporate trustees. You can have banks like Regions or somebody like that who will step in and manage those funds for the benefit of that person. In fact, when it comes to an adult disabled person in particular, I almost always recommend that the last named alternate be something that doesn't die. So even if I appointed as backup trustee every single person in this room, I just started at one end and said, it's you, and if you can't do it, it's you, and then you, and then you, and we went through the whole room. At the end, it would say Regents. Because, if a plane dropped on us right now, killed a whole bunch. Even those 2 with Regions, but it didn't kill the bank. The bank is still alive, and they can still manage those funds for Leanne. So when it's a disabled person, I usually do recommend that the very last named trustee be something that doesn't die. They're just a name on paper, But if the worst case scenario happens, you've always got somebody who can step in. Does that kind of answer your question? All right, one more, and then if anybody has one, and then we'll do the door prizes. Anybody? Winford, did you get it figured out? All right, just checking. All right, well, listen, hey, I appreciate y'all letting me run my mouth. We'll get Marty up here. She'll do some door prizes. We'll see y'all next time. Appreciate it.